Let's go ahead and begin the Subcommittee of Higher Education. Just found out that our regular chairman, Justin Lafferty, had to do some personal business, so I'm going to fill his role during committee. Let's call the roll first to see about our quorum. Madam Clerk?
Representatives Baum. Here. Cochran. Here. Darby. Here. Gillespie. Here. Hakeem. Here. Parkinson. Chairman White.
Here.
Chairman, you have a quorum.
Thank you very much. Members, anyone have a personal order or comment? Anybody want to recognize before we get started? Okay, we're seeing none. Let's do a couple. We got a little housekeeping as we begin. House Bill 708, number 1, by Chairman Zachary, is off notice at this moment. Item number 2, 646, by Chairman Faison, deals with the lottery calendar. We'll be going to the lottery calendar, assigned to the lottery calendar. Item number 3, we will be hearing today. Item number 4, by Chairman Terry, we will be hearing. Items number 5, by Chairman Vaughn, that is rolled for 1 week. House Bill 443. Item 6, by Chairman White, that is a lottery bill we put on the lottery calendar, as well as item 7, House Bill 471 by Chairman White, going to the lottery calendar. The lottery calendar, by the way, is March the 23rd. So we hear all the lottery bills. If you know of anyone, I need to make this announcement on the floor, but anyone that has a bill that deals with the lottery, need to go ahead and put it on notice so we can assign it to the lottery calendar, if you have one of those. Okay, so that brings us to members. We're going to start with item number 3, House Bill 576 by Chairman Reagan. Sir, you're recognized. And I would need a motion and a second to begin the discussion. In a second? Okay, I'll give you a second. You're ready.
Thank you. Committee members, I'm going to do something I don't usually do. Each of you should have received an email copy of my talking points. So rather than dwell on the talking points, what I'm going to do is give you the background very quickly of what we're talking about here so that you will understand why this bill exists. I have here a letter that was sent to the Tennessee Department of Education Office of Civil Rights, August the 29th, 2019. That's 18 months ago. This letter was sent out over my signature as the chair of the Joint Government Operations Subcommittee on Health, Education, and General Welfare. I got that backwards. Education, Health, and General Welfare. What this letter did was point out to the Office of Civil Rights in the Department of Education that they were in fact in violation of several portions of our state code. And specifically, I asked them in the paragraphs of this letter to remove any intent and wording in their documents beyond that which was specifically specified within the scope of Tennessee Code 4-4-123, which I'll read to you in a minute if you choose, and to modify their internal guidance and website relative to Title IX to remove the intent and wording that was incompatible with TCA 4-5-103A2. To this day, they have not. In fact, just before I came to committee, I copied from their website their manual, which basically says that they are able to hold proceedings to withhold state and federal funding from our LEAs, that they may suspend. That was page 10 of their Office of Civil Rights Investigation Manual. Page 11, it says to suspend and terminate state financial assistance made available through TDOE, our own Department of Education. Now, the problem with that is that 4-4-123 does not give them that power. They are exercising power that they do not have under federal law or state law. And oh, by the way, I will mention also that the second portion of this bill, which includes universities, which under their offices of diversity and inclusion are doing the same thing. We also have state laws, and This is 4-5-103, which says, administrative agencies shall have no inherent or common law powers and shall exercise only the powers conferred upon them by statute or by the federal or state constitutions. So we have examples here of agencies within our own state government that are violating state law. Now, I can get into excruciating detail if you like, but what this bill is about is essentially saying, you don't get an exception. You must follow state law. And the bill specifically lays out some things that they must do. And again, in the bill, let me back up just a second. The origin and genesis of this bill began during the Obama administration with something known as the Dear Colleague letters. The Dear Colleague letters were published by the U.S. Department of Education, where they were putting out policies and telling anybody that was receiving funding, federal funding, that they had to comply with these policies. Among these policies were the transgender exceptions and so forth. Now, that is a violation of federal law, as well as a violation of our own state law, which tells our state agencies that they can react only to statutes and regulations, not federal policies. This bill specifically repeats that. The Trump administration came in, within a month withdrew that guidance, and the Department of Education under the Trump administration promulgated the change in the Code of Federal Regulations, which basically means now that we have to comply. But they took out that stuff that was objectionable, and, well, let me rephrase that, not all of it. But anyway, the point is that now that it's in federal regulation, we, as a state and our state agencies, must comply with it. But we're still in a position where we cannot, should not, may not comply with policies that are promulgated. Now, a number of our universities are running around wringing their hands and screaming, oh dear, the sky's falling, because they're afraid that federal funding will be yanked. And that was the threat that was put forward under those Dear Colleague letters. Our universities have Pell Grants, student loans, research grants, and at the wazoo of federal funding that comes to them, and they were afraid they'd go bankrupt, which may have been the case had they carried through with the threat to withhold federal funding. Now, the reality is they couldn't have done that without a court action anyway, and they would have lost. But our universities were worried that in the meantime, they'd go broke. And our own State Department of Education, Office of Civil Rights went, we do what we want to. So this bill came about by virtue of the fact that these agencies, whether it's our own State Department of Education's Office of Civil Rights or the Office of Diversity and Inclusions in our various universities, are not allowed by our state law to react to those policies. If it's not a statute passed by Congress or it's not a federal regulation in the CFRs, they're not bound by it. In fact, they're specifically, by our state law, prohibited. And that's been going on for quite a while. I just read to you an excerpt from a letter that I sent them 18 months ago. Now, to our state universities' credits, they have reacted by changing student due process laws, which was one of the things that Code of Federal Regulations that was changed under the Trump administration required. All of them have come before government operations promulgating rules to do that. This bill is going to require them to promulgate more rules, which will change policies that they have into rules. Now, lest you become concerned, or they become concerned, I want to go on the record. To change a policy into rule, all they've got to do is just go through the rulemaking procedure. They don't have to change what the policy does. That rulemaking procedure basically says you file it with the Secretary of State, you put it through the Attorney General's office, you have a 60-day public comment period, you bring it before government operations, so that the people, i.e. those that we represent, have a chance to say this is good or not. It's not done in the back room. That process is the same. The same policies that they have can be converted to rules. There is no requirement to change. Some have run around and said, well, what if they change the policy and say we're going to cut the money if you don't do that? Our state law has something called emergency rules. you can promulgate an emergency rule just like that. And specifically in our state law, it says if federal funding is threatened. So the fact that they put something in a rule does not mean that they can't change it to save federal funding. They can. So all the running around, hair on fire kinds of things are not justified. They have the power to do that. The Department of Education, on the other hand, has basically told us, the General Assembly, we don't care what you say. We're going to do what we want to anyway. I just quoted you what I pulled off the internet, off of their manual, literally minutes before I walked down here. And yet I asked them, as the chair of a government operations subcommittee, 18 months ago to change that. That is unacceptable. Flaunting the law is something that we should allow no executive agency to get away with. It is our duty to hold them accountable. Now, I'm sorry if I waxed overly eloquent and passionate there, but I do want to point out that this bill is basically saying to those agencies that you will comply. And it cites Title VII and Title IX federal titles, which they are already complying with anyway. It merely says you can no longer do this with policy if it, by the way, the definition of policy is also included in our own state code. Essentially, a policy is anything that is within the walls, or if you were the wiring diagram of an agency. If they want to, they can tell everybody to wear a black suit on Wednesday, and that's a policy. If they want to, they can say fill out Form 1297, Form A on Tuesdays and pass it on Wednesday to somebody. That's a policy. But the minute they do something that affects somebody outside of their agency, as in money allocations or requirements that they must do certain things, it must be done by rule. That's clearly stated in state law. So once again, I'm appealing to you, and I apologize for waxing overly eloquent again, but I'm appealing to you to make sure that our state agencies are indeed setting the example. We require everybody else to follow the law. By golly, our own state government should follow the law. With that explanation, Mr. Chairman, I stand ready to answer questions.
Thank you, Chairman Reagan, and you wax elegant very well. So thank you for that explanation. Members, if you remember, this bill was before us last week, and we had some discussion, and we also had higher ed, as Chairman Reagan mentioned, and they've got heartburn over this. We do have two people that requested 24-hour notice to speak on this bill, and I can recognize them if they still desire. May I call your name? These are what I had on my list that requested 24-hour. Mr. Brian Lapps, TBR General Counsel, is he here? Before you come up, sir, I'm going to see if the members have any questions for Chairman Reagan, and also Ryan Stennett or David Whitcomb of the UT General Counsel. Are they here? Okay, so they are here. Okay, but before we go out of session or anything, let me recognize some of our members. Chairman Bond.
Thank you, Chairman White. And I've got a question or two, and it might be best for me to ask Chairman Reagan these questions, and then if he wants to, I don't know that he's going to want to defer any of them to the guests, but then they would have heard the questions and could comment on them. I don't know if that ordering makes sense. Yeah,
let's go ahead and address questions to Chairman Reagan first.
I understand that part of the motivation for this bill is the 2011 Dear Colleague letters by the Obama administration. I think that irritated Chairman Reagan, and it irritates me too. I understand all that. I think that's partly gotten us into this mess, is some of the events that occurred inappropriately 10 years ago. And then to compound matters, the State Department of Education isn't handling these requirements quite right either. The first part of this bill deals with the State Department of Education, but the second part deals with higher education and our colleges and universities, and it's really that part of the bill that I want to make a few comments on or ask a few questions about. I think our universities are concerned about this, and it probably largely boils down to money, and you've said that, so I'm not really saying anything new. I think it's important to realize that probably 20% or more of the funding for these colleges and universities comes from the federal government. We've got some large institutions that this amounts to over $140 million a year, so it's a lot of money. And these universities are concerned that if they're not in some type of compliance with the federal government, that they're going to lose this funding. Now, I know Chairman Reagan has said that the universities can jump through hoops and take the matter to court and win in court, and universities have won these type of issues in court before. But I think that still creates a certain amount of uncertainty for the universities. Anytime you're dealing with 140,000, 140 million, that amount of money, I think that the universities are concerned about it. The court battle may take some time. There could be some legal fees involved. And so I think the universities want us to consider leaving them out of this bill. Maybe if the bill has two parts, a first part and a second part, keep the first part that involves the State Department of Education, but maybe not keep the second part that involves our higher education colleges and universities. I guess maybe my question, or maybe my first question is, some of this federal guidance may be useful. Would it be a problem if the federal government is giving useful guidance, helpful guidance, and colleges and universities by this bill are not permitted to respond to it?
Chairman Reagan?
Thank you. Good question. And the answer is, by this bill, they may respond to it. They just may not respond to it by policy. They must respond by rule. Now, if it affects anybody outside of the agency we're talking about. And again, we have several means available within our state law. There's emergency rules. There's proposed rules, by the way. And then there's the normal rulemaking process. The normal rulemaking process is the longest, one that we prefer. However, as I mentioned, the emergency rule process is now. It can happen now. So changing a rule is not something that is going to necessarily take a long time. To your point, if they find it helpful, they can, as I said, implement an emergency rule, or they can implement the proposed rule. Within the Government Operations Committee, which I chair, we allow proposed rules which are in fact designed to take care of administrative kinds of things within the bounds of what they already have on the books. We prefer to have the public weigh in on it, though, even if it's a good thing. And there's nothing wrong with it in my mind, because they are public institutions. We, the taxpayers, pay for them. Federal government might give 20%, but we, the state, give most of the universities at least 30%. So we've got a bigger stake than the federal government does, and we should not be ignored. Did I answer your question, sir?
Yes, I think so, and I think you're saying that the universities can respond to good guidance, but they have to do it in the form of a rule.
Yes, sir.
Now, I think maybe the phrase in this bill that's causing the most concern, I guess, is the phrase in Section 2, Part B that says, it's just one sentence, it says, of course, I guess you have to consider the full context, it says, not include policy guidance issued by the United States Department of Education. So it really prohibits using policy guidance from the United States Department of Education. Would it be more flexible if we said that colleges and universities have the option of using or not using policy guidance by the United States Department of Education? In other words, instead of having a prohibition, make it optional. If it's good policy, it could be incorporated, and if it's bad policy, it doesn't have to be incorporated by state law.
TCA 4-4-123 gives specific guidance. And essentially, it's also contained in 4-5-103A2. It says they must react to statute and regulations, not policy. The not policy is added, but obviously, if they're reacting to statute and regulations, it's not policy. So we're demanding compliance with existent state law.
Right. Yeah, I understand state law already says that rules should be made and not respond to guidance. I think, I guess to kind of reiterate, I think a little bit of the concern is with Part B here, Section 2, Part B, that is a prohibition instead of instead of giving the option, but I understand what you're saying, that state law already says that responding to federal policy guidance is prohibited, and so your bill is consistent with existing state law.
Basically, I've just restated what is already in the code in different words.
Let me ask one final question.
You're recognized.
Let's suppose that the federal government did attempt to withhold $140 million from a college or university because they weren't responding the way the federal government wanted to a Dear Colleague letter. Let's say that event actually happened, and the matter had to go to court. Would there be a lag time before the court could resolve the matter, and in the meantime, the university's out this amount of money? Even if they win the litigation ultimately, is there the chance there'd be a lag time where the university would go without, say, 20% or more of their budget?
The answer to your question is possibly. However, I'm sure that my colleagues that went to law school would tell you the first step would be get an injunction to withhold or stop that enforcement mechanism until the court case is resolved. I will mention, too, that the idea that they can force our institutions to comply and enforce federal law is something that's been litigated numerous times. I think, let me quote Prince versus U.S. Supreme Court decision from 1997. The federal government, we held, may not compel states to enact or administer a federal regulatory program. This doctrine didn't just start in 1997. I went back to 1819, McCulloch versus the state. All sovereign power remains undiminished in the states except those cases where it has by Constitution expressly and exclusively transferred to the United States. The point I'm trying to make here is the state of Tennessee is not forced to do the federal government's bidding just because they put out a policy. By the way, as you can tell from the thickness of my page here, I'll be willing to give you more if you want, but I think it establishes the purpose. Those two court cases, one which is very old and one which is fairly new, the same principle. And I will point out, too, that that injunction that I mentioned has been used in several cases already to prevent the enforcement of those mechanisms.
Well, thank you for your responses and for answering my questions. I think your responses are very well thought out. I'm just not concerned we want to run the risk of some of the implications that might occur by forcing our universities and colleges into some of this, but I understand the response to these concerns is in many cases already laid out in Tennessee code. I realize that, but I can also understand why these institutions of higher education are concerned about the implications of what would happen if they were to lose federal funding. But thank you for answering my questions.
Thank you, Chairman Bone. Representative Cochran?
Thank you, Mr. Chairman. Chairman Reagan, you'd mentioned earlier some policies maybe that are currently in place that should be in rule rather than policy. Would you have an example maybe of one of those?
I certainly do.
Okay. I figured you would.
In fact, I quoted two already.
Okay.
From the Tennessee Department of Education Office of Civil Rights Manual, page 10, it says that the TOCR, which is the acronym they use for themselves, will terminate a resolution agreement after 3 or more requests to address deficiencies and corresponding failures to comply, et cetera, et cetera. And then it says, after termination, TOCR will issue a final statement of noncompliance to the recipient and initiate proceedings to withhold state and or federal funding. Here we have a state entity enforcing a federal doctrine / policy. And that's in violation of that first court case I mentioned, Prince versus U.S.
Okay. And then would there be one that in higher ed that you might have in mind? Maybe a similar situation in higher education, or?
Well, fortunately, higher education has addressed the situations that were most onerous, and those were the student due process. And I want to compliment our universities because every one of them has brought forward a change in rules to comply with protecting student rights through due process. And this is merely an extension of what they've done already. the idea is that there's not going to have to be a massive change. They've already made the massive change. This is just cleanup work that says, hey, you've done it over here, just continue it on over here, and we're good to go.
Gotcha. And that's kind of what I was, like I said, I think that we could probably work through maybe some of the higher ed issues, but I share your outrage on what the policy you just shared with us from the Department of Education. That's
By the way, there's another page I can quote for you if you want.
Absolutely. Well, hey, like I said, I think that's something that needs to be addressed, and I, similar to Representative Baum, I wonder if there's a way that we could, at least in the interim, while we're kind of thinking through how to address higher education, if there might be a way that we could kind of focus this in on the Department of Education, kind of take them first, and then look at higher education. I don't know if that's something that you might be willing to consider or look at.
The answer to your question is I have. And as I mentioned already, it's already in the TCA. This bill restated what was in the TCA already. And it made it, shall we say, perfectly clear, whereas there may have been some question. It's now perfectly clear what's in the TCA with this bill. I don't have an axe to grind with higher education. I have 3 University of Tennessee satellite campuses in my district. I in no way want to hurt higher education.
And I just have one quick follow-up.
You're recognized.
And then just one again, the same subsection that Representative Baum had mentioned, I think Section 2 B, not include policy guidance issued by the United States Department of Education. Would that, so looking at the higher ed again, so let's say maybe they got a policy guidance from the U.S. Department of Education that they liked, right? Let's say that it's nothing crazy, but it's something that they see and they think, well, maybe that's probably something that would be helpful for us to adapt or to adopt to our policies. So with that subsection, could they take that policy guidance that they like and then still come to GovOps and say, we would like to promulgate a new rule based on this policy guidance because we think it would be effective at the University of Memphis or the University of Tennessee? Is that possible for them to do?
It's not only possible, it's the way we normally do business.
Okay. So you don't think that subsection prevents them from doing that?
There is no prohibition on them promulgating rules to do what they want to do.
Okay.
The prohibition is on them saying that the federal government policy is us, therefore we must do it.
Okay.
That's already in other portions of the TCA.
Okay. Thank you, Chairman Reed.
Representative Hakeem.
Thank you, Mr. Chairman. Chairman Reagan, one day I hope to have the depth of knowledge and understanding you have when it comes to a lot of our policies and guidelines and things of that nature. And I commend you for that, sir. What I wanted to ask you is that how much do we benefit, so to speak, from putting our institutions of higher learning, in my view, between a rock and a hard place, between state and federal compliance? And, we can be right all day in regards to whether state policy or federal policy should guide it. But what impact does it have on the institutions that we love and want to see to continue to be successful? So I'm saying, are we hurting ourselves? Are we cutting off our nose to spite our face because state policy and federal policy say something, and we have our institutions, in a sense, caught in the middle?
The issue is not policy, but law. State law. I didn't quote state policy. I quoted state law. And state law, from that court case that I just read you now, do not misunderstand me. I am not saying that the supremacy clause of the U.S. Constitution is invalid. Federal law trumps state law. But the key phrase is federal law. It's not federal policy. Our institutions are state institutions. We have chartered them within the state of Tennessee. They are, in fact, for lack of a better term, the equivalent of persons within our state. Everybody is obligated to follow the law. Up to this point, they have not been in some cases. This bill simply says it's already in the law, you must follow it. And it's restated in such a way that it's patently clear. To your point about hurting, I submit to you that you live by the book. If the book's wrong, you change the book. That's our job. We write the laws. If our state laws are such that we need to change them, fine, let's do it. But in the meantime, we don't give somebody an excuse to ignore them. And frankly, that's what's been happening. And I can't in good conscience stand before my constituents, especially some who've come to me with some of their relatives currently incarcerated for having violated state law, and tell them, well, I'm sorry, your son violated state law and he's going to have to serve his sentence, when they say, well, we've got institutions out here that are violating state law and getting away with it. That inconsistency, I'm going to use the word hypocrisy, is something I just won't tolerate. Again, if the book is wrong, the law book, those green books on that shelf there, it's up to us to change it. And I'm willing to entertain changes. In fact, I have changes from many, many sources, and I submit all of you are as well. But when we have a situation where we have discovered that violations of the law are taking place, and it's patently obvious, and we choose to ignore it, we ourselves are becoming hypocrites. And I, for one, won't stand for it. Did I answer your question, sir?
Yes, sir, and thank you, Mr. Chairman.
You're welcome. Okay, that was the three members I had that wanted to ask questions. It sounds like, judging from the comments, the three that spoke, and even the question I have on mine is, the issue is the higher education, getting that worked out, putting them between a rock and a hard place. You have waxed eloquently and on your position. Members, does anyone want to hear from the two guests that asked to speak in higher education? Would you like to go out of session and hear from them? Okay. Without objection, then, we're out of session, and I'm going to invite up Mr. Brian Lapps, TBR General Counsel, Tennessee Board of Regents. Mr. Lapps, you can come to the podium. It'll be fine. And since we're audio video streaming, just state your name and position for the record. Is the mic still on? Look, see if there's a red button lit up. There you go.
Brian Lapps, General Counsel, Tennessee Board of Regents. I'd like to thank you for the chance to speak today, members of the committee, and I'd like.
There you go.
Okay, thank you. I'd like to thank the members of the committee, the chairman, and as well as Chairman Reagan for the conversation he had with us last week to address some of our concerns. But I think the questions have hit the nail on the head in terms of putting us behind a rock and a hard place. I share Chairman Reagan's problems with the federal government issuing guidance and then expecting us to follow it and changing that guidance as they go along. I have trouble with that. I don't like that as a lawyer. I don't like that as a higher education lawyer. I don't like that as a citizen. But as General Counsel for the Tennessee Board of Regents, my job is to avoid that rock and a hard place, or the choice between a Pyrrhic victory or a loss. And it's not just the fact that we could be sued. It's the fact of what happens if the federal government does try to get rid of our federal funding. Will it come to that? Probably not. Would we change things? Yes, but there's still a lot of collateral damage in terms of the time it takes to fight that, in terms of the other things the federal government can do, the other investigations they can undertake, the other fines they can try to levy, and the other things they can look for us if we're doing wrong that could be collateral damage on that. The Tennessee Board of Regents has $230 million of federal money for the last budget year. I think $211 million was the number I saw that was federal student aid. So it's not just the institutions, it's the students. And with respect to Tennessee Promise, at least, the federal money, or the state money, the federal money comes first, and then the state money comes after that, as this committee well knows. So if there's any decrease or a risk of decrease to federal money, it's also affect us on the state money issue. So if we might win, we well might win. But avoiding a long, drawn-out fight with potentially adverse consequences like enrollment declines, additional time, effort, and energy with all of higher ed in turmoil trying to figure out how we're going to deal with this is just not something we really want to be in position to do. And to address Representative Baum's question, it is Section 2A2 that I think is, for at least me, is the real issue, which provides that rules promulgated pursuant to the subsection A must not include policy guidance. That applies to, as I read it, emergency rules, proposed rules, and rulemaking rules. So I just don't want to get caught in a situation where we're threatened with the loss of federal funding and we have to face the position of getting into a big fight about that. And that fight could well happen because the Dear Colleague letter, the 2011 Dear Colleague letter that really set this issue off, it is going to be, well, the Title IX regulations that replace that Dear Colleague letter are in the crosshairs of the current administration. They have said that they want to change those. I don't know whether they're going to repeal them in toto or repeal portions of them. I don't know whether they're going to repeal portions of them and then issue guidance while they figure out what they want to do. We just don't know. And they're also likely to resume what 2 administrations ago did with respect to issuing Dear Colleague letters. And when they do that, we still run into the problems of, okay, now what do we do? And I just don't want to have our hands tied. I want to be able to respond to these changes as they come up. And I'm concerned that this bill ties our hands, and it's just not in the best interest of higher education in general and the Tennessee Board of Regents in particular.
Mr. Lapp, is this a fair statement? We all on this committee could agree 100% with Chairman Reagan in his position. But because we cannot really know what the federal government may or may not do, that's the issue. Is that
Yes,
am
sir.
I paraphrasing that right?
Yes, sir. That's a very good phrase of it.
Okay. Representative Cochran?
Thank you, Mr. Chairman, and appreciate you coming to testify and giving us some legal expertise there. So one follow-up question, just on the threat of losing federal funding. So without this, the current bill that we're debating, if the federal government were to issue, let's say, some Title IX policy guidance, the higher education institutions implement that they take that policy guidance and they change a rule. Then they come to the Joint Government Operations Committee to then get that approved. We think that policy guidance is outlandish. We think it's really kind of far outside the mainstream, and we say no. Yeah, that's not we're putting a stay on that rule. You're not going to do that. Is that not the same risk to federal funding, or if not, why not?
I think there is. I'd say it's a similar risk. If we come now and you say no, there's that risk to federal funding. But as I'm reading this bill, it says we shall not include federal policy guidance on it.
Okay.
And it just causes additional problems and additional risk. I think it's in the same nature, though.
Okay, gotcha. And I certainly understand the university's concern, and I think we want to make sure that we get the language right. I also want to say, though, at some point, I think we do have to take a stand, even if it does possibly put federal funding at risk, or if we have to have that fight. I mean, that's a fight that we have to have. If at some point federal guidance is issued that is outside the mainstream of the citizens of Tennessee, the people that we work for, I think we have to say, all right, hey, if it's a risk of federal funding, we're saying we're not doing it, and we'll see you in court. And so I understand the concern, but I also want to make it very clear at some point we have to not be afraid of the risk of standing up for the values of Tennesseans. So, but I appreciate what you came to say.
Well, thank you. And I understand that principled position very well, Representative Cochran. I just, as an advocate for the Tennessee Board of Regents, my job is to try to keep us out of that rock and a hard place. Thank you.
Anyone else want to talk to Mr. Lapps? Okay, seeing none. Thank you, sir. Appreciate that very much. We also had, was it Mr. Stinnett?
Yes, sir.
Oh, why don't you come on up and see if any members have a question? Just about a minute or two, and then we'll have some questions, and we'll move on. Go ahead, and you're recognized.
Thank you, Chairman. My name is Ryan Stinnett. I'm the General Counsel for the University of Tennessee System. And I just want to make a few points, starting with appreciation for Chairman Reagan's concerns and appreciation for him taking time last Thursday to talk with all of us from higher ed. We had a really good conversation. Again, we respect his concerns, we understand his concerns, but we must respectfully disagree on this bill. And I just want to point out, reiterating a little bit of what Mr. Lapp said, really what our concerns are in higher ed. First, we think this bill is duplicative. As Chairman Reagan has said multiple times, this is already in the APA to a large degree. We've got definitions of what a policy is and what a rule is. And Chairman Reagan pointed out, I believe moments ago, that higher ed is doing a good job of complying, of making rules where rules should be made. We are in compliance with Title VI. We are in compliance with Title IX. We have a lot of oversight. We submit reports on Title IX every year to the Tennessee Comptroller. We submit reports every year on Title VI to the Tennessee Human Rights Commission. There's state oversight on what higher ed does in this area already, and we just feel like this bill is duplicative of that. We have an Administrative Procedures Act, and we believe we comply with it. As to the flexibility point, we certainly agree that higher ed needs flexibility so that, to your point, Representative, we aren't stuck in that between the rock and the hard place. When we have federal guidance and we have state expectations, higher ed gets caught in the middle. We are at risk of losing funding, or even if we win that lawsuit down the road, we're at risk of losing funding temporarily. We're at risk of having to expend the money to litigate one of these cases. As to the point on emergency rules, Chairman Reagan has pointed out that if we get federal guidance and we need to respond to it, we could issue or promulgate an emergency rule. Our reading of this bill would actually prohibit that if that emergency rule is incorporating federal guidance. I think that Section 2 that you're all talking about, would say, I think the literal interpretation of that language is, if we're promulgating an emergency rule, certainly it lets us be more nimble, be quicker, but if if it's based on or incorporates federal guidance, I would anticipate the Government Operations Committee having an issue with it if this bill were to pass. I think the other point that I think is just worth making is there is a significant, to Chairman Reagan's point about the rulemaking process, his committee, Government Operations Committee, has asked that higher ed do notice and rulemaking, so not the proposed rulemaking approach, and that's what we're doing. So that process is quite burdensome from an administrative process. It takes a number of months, a lot of hours of work. We're happy to do it. That's what the committee has. It's at the will of the committee, certainly. But if this is going to lead to a lot more rules that higher ed has to make, it does create an additional administrative burden that is concerning for us as well. Be happy to answer any questions you may have.
Thank you very much, members. Any questions of our guest while he's up on the podium? Seeing none, thank you so much.
Thank you.
Okay, without objection, we're back in session now, members. Okay, Chairman Reagan, we have House Bill 576 before us. Members, any more questions to Chairman Reagan at this time? Chairman Reagan.
Sir, may I make a closing statement?
You may, and then we'll make a comment. Yes, sir.
My closing statement is this. These fine gentlemen representing higher education have made good points, but let me distill it down to the core. As a matter of fact, let me draw an analogy. I seem to remember a story about 30 pieces of silver for betraying principle. What you've heard objections about is we're going to lose 30 pieces of silver that the federal government is giving us if we don't do what they tell us to. I submit to you that's the equivalent of financial blackmail. We are either a sovereign state, and I read you a court case that cited that, or we're not. If the federal government is going to say, do what we want, or you yank your money, and we go, oh dear, we've got to do what they say because we can't stand to lose the money. I'm sorry. My attitude is keep your 30 pieces of silver. We'll make it work. Thank you, Mr. Chair.
Thank you, Chairman Reagan. Chairman Reagan, do you see any, okay, let me go ahead and go to Representative Parks, and I'll come back to myself. Representative Parks, you're recognized.
Thank you, Mr. Chair, and Chairman Reagan, thank you for your comments in regards to the leveraging of money from the federal government to the state. If you don't do what we say, we're going to take the money away from you. But, Mr. Chairman Reagan, respectfully, I submit that is exactly what the state does to our counties and our cities. And so it appears to be that the abused is abusing also. And, you know, and I would love to support you if we could get the same guarantees that the state won't bear down on the cities and counties as the federal government is bearing down on the state. And you know, and we cannot say one or you know, without saying the other. And so that's all I wanted to point out in this discussion. And thank you, Mr. Chair. Thank you, Chairman Reagan.
Chairman Reagan.
Mr. Chair, I would respond in this fashion. The state is a sovereign entity. The states created the federal government. Cities and counties within our state are subunits of state government. They did not create state government. State government created them. In fact, we used to have one more county than we have now. The state government created and then dissolved it. So those entities do not have the same rights toward the state as our state has toward the federal government. Bearing down, as you called it, is the function that we serve up here. We represent those people. If we choose, then that's the way it is. However, within our Constitution, we must abide by those rules. And what I'm saying is there is no fourth branch of federal government. There is no administrative branch. The Department of Education, as an administrative agency, does not get to tell the sovereign state of Tennessee, you must do this. Whereas the state of Tennessee can tell the non-sovereign county of Stewart or Anderson or Knox or pick one, you must do this. And that's within our Constitution.
You're recognized, Representative Parkinson.
Thank you, Mr. Chair, and thank you, Chairman Reagan. And I understand that, and I don't necessarily disagree with you at all in what you just said. But it's a matter of how you use your power. You have power, and yes, you have power. We all have power up here. The governor has power, so does the United States Congress and Senate, which all represent us as states. That's the only part of what you said that I disagree with. Because there are representatives up there too, and they can make this decision. We voted them in to represent us. Now, but here's my thing. I just want to impress this upon everybody in this room and everybody watching. Yes, you have the power to make these decisions and leverage money over the cities and counties, but it's how you use your power when you get that power. You know, we have the power to either build or destroy. All of us up here in this dais. And how we use our power is what counts. Because if you look at some of the things that are happening to some of our cities and counties, you know, coming from this organization, we are using our power not necessarily to build, but in a lot of cases destroy. Now, doesn't abdicate the fact that you have the power because we're a sovereign entity and the cities and counties are not. That's understandable, and I have no pushback on you with that. But where I do have pushback is how we choose to use our power. Now, the federal government is choosing to use the power of the purse on the state of Tennessee, based on what you're saying. We choose to use our power to bear down on counties when they don't do, or cities when they don't do what we want them to do. Now, but we don't have to. It's a choice. And so I'll leave it at that without making this a running debate, Mr. Chair, and Chairman Reagan, respectfully, you know, I submit that. Thank you, Mr. Chair.
Thank you. Representative Hakeem, you had a question over Chairman Reagan?
Yes, it's a brief comment, if I may. And I guess it's not always what we say, but the way we say it. And the piece about 30 pieces of silver, I believe it was, I think if we look at our institutions of higher learning, if the numbers I heard correctly, about 80% of those dollars that come from the federal government goes to the students. And so it's not a matter of, just getting money and hoarding it, but these are monies that are utilized for our children. And if the federal government doesn't do it, and if we want to at least keep the level of our young people graduating from college, that means that we're going to have to come up with additional dollars. And that's a concern I think we all have, coming up with additional dollars when we should be getting our share, so to speak, from the federal government. Thank you, Mr. Chairman.
Thank you. Okay, anyone else would like to ask Chairman Reagan? I guess where I'm coming down right now, you've done such an eloquent job of presenting this. Do you see any opportunity to work with higher education and help them to ease any issues as far as making this palatable to them? You recognize?
Well, as was pointed out, I met with them. I also met with the president of University of Tennessee, as a matter of fact, Friday of last week. And I have reached out. The issue, with due respect, let me specify here, the issue is not telling them that they can't do this. It's telling them that they must do it in accordance with the law. The law says, and I quoted it to you, that they have to react to statute and regulations, not policy. And as was pointed out, one of them said, yes, it's duplicative. And it has been duplicative because these have been on the books. Well, I couldn't tell you how long. They were on the books for as long as I could look back. And I would point out, they have not adhered to them. If it's on the books and they ignore it, what are we going to do? I understand the concern over the money, but let me state again, uncategorically, anything that is a policy can be made a rule. It's not hard. If it affects somebody outside of their organization, that is to say, in the case of higher education, one of their students, one of their contractors, or maybe a visiting team that's competing against us, fine. They can still do what they want to do. It's just they can no longer do it with a stroke of the pen and nobody know about it. Rules must be promulgated. Rules can be heard. We can know what's going on. We're not telling them what they must do in that respect. They can do what they want to. We just say the way you do it. You've got to do it with full transparency, creating rules. And I would submit to you that we, all of us here, the guardians of our Constitution. Our Constitution does not allow you to follow the rules, i.e. the law, part of the time, and not when you don't want to. I'm simply asking with this bill that we do it all of the time. Thank you, Mr. Chair.
Thank you, Chairman Reagan. Members, I feel like a non-lawyer on the Supreme Court. I'm trying to figure this one out. And I'm trying to be a fair arbiter on this. I hear my higher ed and their concerns, and I hear you make such eloquent points. Are you wanting to bring this to a vote today?
Mr. Chair, I'm at the will of the committee. I would point out that if we don't vote on it today, I've already rolled it once.
Yeah.
This would be the second roll.
Yeah. I'm just asking if you want ready for us to take a vote.
If I understand what's going on, that means it
Okay.
automatically goes to the last calendar of this committee, which means that it's going to be then impossible to be heard on the full committee and get to the House floor.
A member has called for the question. Is there any objection on the question? Hearing none. All those in favor of moving House Bill 576 out of committee indicate by saying aye. Opposed? No. Fails for lack of majority, Chairman.
Thank you, Mr. Chairman and committee.
Thank you, and thank you for such an eloquent job. You taught us a lot. Members, we got one more. We've got one more. Chairman Terry, House Bill 1056, I believe. Chairman Terry, you're recognized. We got a motion. Did I hear a second? Second.
Thank you, Chairman and committee. This bill actually is something I worked on last session, and I was unable to run that obviously because of the pandemic, and I worked on the concept with the University of Memphis and University of Tennessee, and the bill that you have before you is language that they presented to me. This body previously passed the Campus Free Speech Protection Act. In Section 49.7/2405, it directs the governing bodies of every institution to adopt a policy that affirms 17 principles of free speech, which are the public policy of the state. I've consistently heard from students and professors that there are issues on campuses related to free speech as it relates to political viewpoints, including the need for students sometimes for self-censorship, for risk of their grades, and for risk of getting recommendations. The Yale William F. Buckley program surveys students on this topic of free speech, and they consistently report that students feel intimidated and restricted in their expression of their ideals. And additionally, a report came out last week from the Center for the Study of Partisanship and Ideology that spoke to political discrimination in academia. The second principle that this bill is amending, that current statutes says, an institution shall be committed to giving students the broadest possible latitude to speak, write, listen, challenge, learn, and discuss any issue, subject to Section 49.7/2408. And this bill, as it's written, simply amends that to add in including political viewpoints, and then subject to that Section 49.7/2408, free from discrimination or retaliation based on the content or viewpoint of the student's expression.
Thank you, Chairman Terry. Members, any question on this? Representative Parkinson?
Thank you, Mr. Chair. Chairman Terry, where can I sign on?
I'll get you a form.
Thank
Thank you
you,
very
sir.
much.
Chairman Terry, is this having dear colleague letters in it or anything like that? I've heard nothing but good support on this. I'm in favor of your bill. Anyone else want to? Question been called. Any objection to the question? Hearing none. All those in favor of moving House Bill 1056 out of this committee into full committee indicate by saying aye. Aye. Opposed? The ayes have it. It moves out.
Thank you, Chairman and Committee.
Members, I believe that completes our calendar. We got a motion to adjourn. Any objection? We are adjourned. Mark, that was a tough one.